The Supreme Court of Canada has a big New Brunswick case to decide. Does the Constitution require that the person living here, the Crown's representative, the Lieutenant Governor, speak both English and French? And that question is causing a political and legal conundrum for Premier Susan Holt. The Holt government filed this submission in July, arguing it is not constitutionally required.
Plus que jamais, nous avons besoin de votre appui.
The Acadian Society has urged its members to write to their MLAs and the Premier to pressure them to withdraw that argument. There's been a lot of criticism of the position in the French language media too, with letters and articles calling the province's filing a slap in the face. Justin Trudeau appointed Brenda Murphy in 2019. She did not speak French, though she improved her ability to read French during her term.
Madame la Présidente, honorable parlementaire.
The Acadian Society filed the court challenge, arguing that was unconstitutional. The Higgs government argued bilingualism is not required, a position Susan Holt said at the time she disagreed with. A Court of King's Bench judge ruled bilingualism is required. The New Brunswick Court of Appeal overturned that and said no, it's not. And now, with the case headed to the Supreme Court, the Holt government has adopted the same argument as the previous Higgs PC government, that it is not required. For weeks, no Francophone Liberal MLA would comment on the government's legal position until this.
La lieutenant-gouverneur d'une province officiellement bilingue doit être bilingue.
Thériault said the lieutenant governor of a bilingual province must be bilingual. She also said the last few weeks of pressure and criticism were extremely difficult, but she would always speak up to defend the rights of Francophones. Part of the issue here is that Francophones feel they went 6 years with a premier, Blaine Higgs, who they didn't consider very sympathetic to their language issues. They expected more from Susan Holt. Holt's Liberals have changed the province's legal position once before already on an Indigenous title claim.
We've instructed lawyers working on that file to pause litigation and shift the strategy to negotiation.
But that was a change from the Higgs government's legal position. In this case, the Holt government would be changing or withdrawing its own legal arguments. Holt told a newspaper she didn't consult her cabinet and caucus on this because they should not influence an attorney general's legal position. But there are precedents for that in civil cases that touch on major policy issues. In short, it's complicated and potentially messy, and that makes it a major political test for Premier Susan Holt.